My dear fellow citizen, you are welcome in one more part of procedure for amendment in the series of our Constitution. The changes made by the 43rd and 44th Amendment Acts are summarized in Table 4. Briefly speaking, the 43rd Amendment Act 1977 simply repealed those provisions which had been added by the 42nd Amendment Act to curb judicial review. Article 31D, 32A, 144A, 226A, 228A. The changes made by the 44th Amendment are more extensive. It is not only imitated some more of the articles which had been inserted by the 42nd, as for example Article 257A, 329A, but also made amendments in other articles in order to restore those provisions to their ante-1976 text, as for example Article 226. Apart from combating the mischiefs introduced by the 42nd Amendment, the 44th Amendment Act introduced additional changes, as for example by omitting the fundamental rights to property in Article 19(1)(f) and Article 31(2). Since Janta failed to secure the passage of a number of clauses of the 45th Amending Bill, the stamp of the 42nd Amendment on various provisions such as Article 368 still remains. Besides, the Janta government have themselves retained some of the provisions as amended by the 42nd Amendment which they considered too beneficial, as for example Article 74(1), Article 311 of our subsequent amendments. The 73rd and 74th Amendment Act of 1992 deserves special mention inasmuch as it has introduced the electoral system for the composition of the units of local government below the states, viz. the panchayats in the rural areas and the municipalities in the urban areas. It is evident that instead of being rigid, as some critics supposed during the early days of the Constitution, the procedure for amendment has rather proved to be too flexible in view of the ease with which as many as 83 amendments have been made during the 50 years of the working of the Constitution. So long as the party in power at the center has a solid majority in Parliament and in more than half of the state legislatures, the apprehension of impartial observers should be not so as to the difficulty of the amendment, but as to the possibility of its being used too often either to achieve political purposes or to get rid of judicial decisions which may appear to be unwholesome to the party in power. Judges may of course err, but as has already been demonstrated, even the highest tribunal is likely to change its views in the light of further experience. In the absence of serious repercussions or emergent circumstances or a special contingency, as for example to admit Sikkim by the 35th and 36th Amendments, therefore the process of constitutional amendments should not be resorted to for the purpose of overriding unwelcome judicial verdicts so often as would generate in the minds of the lay public an irreverence for the judiciary, thus shaking the very foundation of the constitutional government. This is all about today's part of procedure and amendment. Thanks, regards.